on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
This courtroom scene escalates quickly. Judge Urich runs a tight ship, and today he's dealing with a man claiming to be a sovereign citizen. It's hard to tell if he's truly confused or just putting on an act. He's facing 2 charges of public misconduct after being caught behaving inappropriately at a public park. Let us know in the comments, do you think he's faking it or genuinely out of it? And if you enjoy courtroom content like this, don't forget to like and subscribe. Let's get into it.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date, you did knowingly make an open or indecent exposure of your person, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member, impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Hartwood Woods, which looks like it was deferred up as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at this time.
We've got to say, Judge Urich really knows what he's doing. I've seen other judges try to handle these so-called sovereign citizens, and they usually either lose patience or end up wasting a lot of time. But not Judge Urich. He keeps things on track and doesn't let the distractions get to him. The way he calmly points out the flaws in their arguments is actually pretty sharp, and even a bit funny at times. Setting the bond at $50,000 was a smart move too. This young man already has several felony charges, and honestly, he shouldn't be back out in public just yet. Hopefully he can get the help he needs and turn his life around. That said, it's hard to tell if he's truly struggling mentally or just pretending. What do you think? Let's get back to the hearing.
If Mr. Stringer wishes to bring various motions before the examining judge, And that could include a motion to modify his bond. That is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on what is going on right now?
I'm sorry, sir.
I'm being charged. I'm being charged with entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
Well, I'm not sure if you caught it, but during the second hearing, he actually said, "We're about to go to war." Honestly, that has to be one of the worst things you could ever say to a judge. If I were on the bench, I would have held him in contempt right then and there. Now we're heading into his second hearing, and this time, it's with a different judge, one who doesn't hold back at all. Things get pretty intense. Let us know what you thought about the first hearing, and now let's jump into the second one.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Lynn Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
Living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mont-Lewis, can you prepare an order for competency review?
What do you think? Did the judge make the right decision by ordering a competency review for this defendant? If you're not familiar, when someone tries to fire their defense attorney, it can cause serious problems if they're not mentally fit to represent themselves. Even though this man believes he's incredibly smart, it's pretty clear he's struggling with his mental health. That kind of situation can really slow down the legal process and even risk violating his right to a fair trial, which might lead to the charges being dropped altogether. If a defendant doesn't understand the charges or how the court works, it's like trying to play a game without knowing the rules. Everything just falls apart. Let's jump back in.
I'm going to wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sanutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels me incompetent? My intelligence, because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I overstand the nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father. and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
I'm pretty confident this competency review is going to show that this man is dealing with serious mental health issues. He's already been charged with multiple felonies, and honestly, it doesn't look like that cycle is going to stop anytime soon. Don't get me wrong, I believe in giving people second chances, but it feels like he's already had more than enough of those. It's hard to say whether he's truly mentally ill or just acting out in line with the usual sovereign citizen behavior, trying to put himself above the law. The fact that he was caught acting inappropriately in public makes me think he might not be well. What do you think? Did the judges in this case handle it the right way? Personally, I think they did the best they could. Maybe putting him in contempt would have changed his attitude a bit, but who knows? Share your thoughts in the comments, and if you enjoy this kind of content, don't forget to like and subscribe. Thanks so much for watching. Take care.